There's an affirmative finding of family violence. There's to be no contact with the complainant. That's Danesha Gray, Danesha. There's going to be credit for any time served. The court will sentence you to 1 year in the Bexar County Jail.
The gavel strikes.
Court is calling 2022 CR 6099, State of Texas versus Marquise. How do you pronounce your last name?
Bosier.
Bosier. Could I have the parties announced for the record for the state?
Ashley Jones.
Defense.
Zachary Munoz.
And are you Marquise Tyree Bosier? Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Marquise Tyree Bosier who was placed on deferred adjudication in 2022 CR 6099 on December 5th, 2022 for a period of 2 years for the offense of assault bodily injury? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. I'm sorry. Give me just 1 minute. The state is proceeding on violation of condition number 4. Would you like me to read that?
Yes.
Violation of condition number 4 on the August 9th, 2024 supplement to the motion to enter adjudication of guilt. In Bexar County, Texas, the defendant Marquise Tyree Bosier, I'm sorry, did then and there fail to report to the supervision officer as directed for the months of April, August, December of 2023 and March 2024. Violation of condition.
How do you plead to that, true or not true?
And Your Honor, I do apologize. The state is going to waive that condition. I read the wrong condition.
Okay.
So the state will be proceeding on violation of condition number 14G. That on or about the 23rd day of April 2024 in Bexar County, Texas, the defendant Marquise Tyree Bosier did then and there fail to comply with the instructions of the Battering Intervention and Prevention Program, or BIP, as directed by the head or authorized personnel of that agency, in that the defendant did not provide proof of attendance in violation of condition number 14.
How do you plead to that, true or not true?
And the state will waive all remaining conditions in all supplements and original.
Any objection to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation 14G, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to 14G? Court will find 14G true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That agreement is to grant the state's motion to enter adjudication of guilt, adjudicate the defendant guilty, and sentence him to 237 days in the Bexar County Jail. That would be a JSAT, and we would ask that time and money.
All right. What has he done on probation?
Your Honor, my understanding is he did complete some of the courses. And he did pay some of the fines and fees.
Did he complete anything? Did he complete the batterer's intervention program?
No, Your Honor, that's why he pled true to that one. He enrolled, unfortunately, as of course well aware, it's quite time consuming and it's quite expensive in my client. Unfortunately, he has a wife and stepchildren that he is the main financial provider. Unfortunately, his wife came down with an illness to where she was unable to work, so he was.
Is there any proof of that?
I don't have the proof for today, Your Honor.
Did he tell probation that he was having these issues?
I'm not aware if it's not notated in the.
Did you tell, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Marquise Bosier.
All right, did you tell probation you were having difficulties? Did you tell them about issues concerning, is this your wife?
Yes, ma'am.
Did you tell them about that?
No, ma'am.
Okay. Did you complete anything on probation?
I believe it was, I had 2 courses. The BIP was the only one that I didn't complete, but everything else I completed.
All right, so you completed the DOEP course? All right, the main course is the BIP, because that's the battery intervention course.
Yes, Your Honor. No, we understand, and that is why, you know, he has been in custody for 237 days. That's why we're asking. It's pled true to that violation. We're asking the court to accept that the current agreement of 237 days and hold that as a judgment satisfied for this case.
All right, and who is the,
The complainant is an ex-girlfriend from years ago, back in 2022 or earlier.
so has he had contact with her?
I've spoken with him prior and no, he has not. He can go on the record, of course, and testify to saying that as well.
And Your Honor, just to clarify for the record, I just want to make something correct for the record. At least in one of the supplementals, it does allege that there is a violation for not completing the supplemental, I'm sorry, for not completing the drug course. That is an allegation that the state is waiving.
Okay.
But I just wanted to have that in front of you.
All right, the court is going to grant the motion, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with the complainant. That's Danesha Gray, Danesha. There's going to be credit for any time served. The court will sentence you to 1 year in the Bexar County Jail. All right, did you review the document? And the court will not do a fine. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
The document that we only bring is this document.
All right, did you review that document with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a conviction with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Your Honor, if I can just explain to him what just
Sure.
occurred so you understand.
Yes. Who's here on Darren Johnson? All right, have you all conferred with Ms. Ferguson on a jury trial date?
We did not, Judge.
How long do y'all expect this trial to last?
3 days, longest.
All right, Ms. Ferguson, I need a jury trial date on Johnson. Ms. Johnson, because there was a snow day, we can't have your jury trial. Oh, I love the outfit you're wearing. You always dress appropriately for court. I appreciate it. So we're gonna do our best to get your jury trial date. So what date? April 1st. All right, so it's gonna be April 1st.
Thank you, Your Honor.
All right, thank you so much.
Thank you.
You're welcome. Once you sign the reset form, you're excused.
Thank you, ma'am.
Your Honor, can we go on the record?
Sure.
Fine, it's misremembering the conversation we had previously.
Oh, what, you want to go on the record with that?
Just to-
Attorney-client privilege.
Yeah, you're right.
All right, let me see him. Could you come down, sir? Let me explain some things to you.
He's failing to understand the jail credit will essentially, if he's given 2 for 1.
So here's the thing. With motions to revoke,
Yeah.
your attorney in the state, they may say, oh, we agree that this is what we want to happen.
Yes, ma'am.
But because that is a contract with the court, it's not a contract with your attorney or the state, I don't have to follow any agreement that you have. With regards to credit for time served, legally, I'm bound to give you credit for any time that you've been in custody. So I sentence you to the maximum amount that's allowed, which is 1 year at the Bexar County Jail. How much time does he have in?
238 days.
All right, you have 238 days in. What I can tell you is I'm not in charge of whether you receive 2-for-1 or 3-for-1. That's the jail. Normally, the jail will give people 2-for-1. So every day that you are in custody, you get credited for 2 days. Do you understand?
Yes, no.
All right. Do you have any other questions?
No.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome. On in attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Counsel, do you wish to proceed with sentence? Court is calling 2024 CR 007543, State of Texas versus Michael Egu. Could I have parties announce record for the state?
Andrew Harris Tatum.
Defense
Tony Hernandez on behalf of Mr. Ugu.
and probation. This is an application. Thank you. Counsel, have you received all discovery? Did you review it with your client?
I have been.
Court will find that the state is in compliance with discovery. Mr. EU, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, and I believe there's a trial amendment on the indictment.
Right, state, are you proceeding on the indictment as presented?
No, Your Honor. State moves to amend the indictment to change the spelling of Mr. Wu's last name from UEWU to UGWU.
Any
No
objections?
objections,
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with assault on a process server. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ego, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. There's to be restitution of $250 to Beatrice Valdez. Did you understand that to be the plea?
Yes, Judge.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
Did you understand by citing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years and there be no contact with the complainant. Did you understand that is recommendation from the state and the court does not have to follow that recommendation?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No comment.
State any evidence.
Containing Exhibit 1 and attachments, Your Honor.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will present evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Counsel, do you wish to proceed with sentencing?
We can, yeah.
All right. Does your client have any criminal history?
He does, Your Honor. He's currently on deferred adjudication for an aggravated assault with a deadly weapon. The court granted his application for deferred adjudication. He seems to be doing very well on deferred adjudication. My understanding is he's finished the classes he's supposed to have done. He is behind on his fees, but it's been challenging for him to find jobs. But other than that, he's doing very well. He reports no UA problems or anything like that. He's doing quite well with it. This particular case predates the granting of the deferred adjudication on the other case, and it was, I guess, sealed for some reason because we didn't see it and the state didn't see it either.
Okay. All right. That explains things. All right. Anything states you're silent on his application for deferred adjudication, so you're excused.
Thank you, Your Honor.
You're welcome. All right. This is what the court will do. The court will sentence you to 5 years deferred adjudication. There's to be a $1,500 fine that will be probated. Anger management. Proof of employment within 30 days. No employment as a home health care provider or with minors. Restitution of $250 and no contact with the complainant, Beatrice Valdez. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month for 3 months. 200 hours of community service restitution. Probation, is there anything else? Is there anything else you need from the court to be successful?
I believe he already took the anger management class under the other probation.
He'll need to speak with probation. If that's been completed, then the court will deem it satisfied because this case predates the probation case.
And just one question, is the additional community service hours, is that in addition to what he's already been given? Is
Yes.
that concurrent?
That's in addition. And if he wishes to pay off the community service hours, he can pay off the community service hours at $7.25 per hour.
Thank you, Judge.
And Judge, that was 200 hours?
Yes. All right, I'm showing you what's entitled trial, excuse me.
I'm sorry, Judge, I thought we were.
No.
I'm sorry.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
All right, we can go off the record. Here's the thing, when somebody comes to serve you papers, everybody's trying to do their job. This is what you can do. You can they'll put the papers in the door, or either you can tear it up after they leave, but you can't put your hands on anybody. You understand?
Yes, Judge.
All right, good luck.
Thank you.
The courtroom session begins as Judge Stephanie Boyd calls the case of the state of Texas versus Maris Tyree Bosier. The defendant confirms his identity, and the judge ensures he reviewed the documents related to the motion to enter adjudication of guilt and the revocation of community supervision. The state outlines the violation: failure to comply with the battering intervention and prevention program, a key condition of probation. When asked how he pleads, Bosier admits the violation, acknowledging that he did not complete the program. Judge Boyd immediately asserts her authority, confirming the consequences, including potential jail time and fines. Despite partial compliance with other probation requirements, the defendant's failure to complete the primary program and failure to communicate difficulties with probation highlight a clear pattern of defiance and neglect. The judge meticulously addresses the proposed agreement, adjudicating the defendant guilty and imposing 237 days in Bexar County Jail. Bosier attempts to downplay his noncompliance, claiming partial course completion. Judge Boyd remains firm, emphasizing the affirmative finding of family violence and prohibiting contact with the complainant. She methodically confirms the defendant understands his limited appeal rights and the prohibition against possessing weapons. Throughout, the tension escalates as Bosier shows minimal accountability for his actions. Judge Boyd's decisive rulings leave no ambiguity. Probation violations have severe consequences, and compliance is mandatory. Every stage of the process underscores the seriousness of family violence and the authority of the court. The session concludes with a final, uncompromising sentence: 1 year in Bexar County Jail. Bosier acknowledges the ruling, but the gravity of the consequences is unmistakable. This case demonstrates the power of judicial authority and the weight of probation violations, leaving a lasting impression on viewers about accountability, family violence, and emotional courtroom integrity.